right. Welcome to the House Judiciary Committee. Again, we're back, and we're gonna not necessarily, even though we have a bill H571, that's a short form bill, which was a vehicle for recommendations from the Firearms Surrender Order Compliance Working Group. This is something that they're working on in the Senate, either on H606 or S329, and we may be seeing it. Language that does, the actual language that implements those recommendations. I had Nate pass out the actual report from that group, and I just want to do kind of an introduction to give us some background for when we do look at the language. So, and I thought that we'd have Carolyn.
Well, this is more of a less a walkthrough at this point.
It's not really a walkthrough. It's a discussion of what the needs were and just what I mean, we passed this last year in the miscellaneous bill to have this working group. And it's just kind of an update on what they recommended. We'll look at the language after after it's settled somewhat, hopefully in the Senate. So, Carol, if you could join us. Thank you for being here.
Of course.
Cool.
Thank you for having me.
So bring us kind of to start the process of understanding this, and hopefully we'll get to look at some language possibly next week, depending on how far the Senate has got done.
Great. Well, I'm Carolyn Hansen from the Attorney General's office. And as the chair was just saying, you all appointed a working group to look at the issue of compliance with firearm surrender orders. So just to kind of set the stage for you, right now we definitely have situations where courts order people not to have firearms. And that's basically it. Don't have a firearm. Nobody asks, what'd you do with the firearm? Nobody knows where the firearm is. And so this work group was formed by you all. And I can give you that number. I open up to my notes here.
You don't have the ability yet to just send them to the cloud.
Okay. Another suggestion. Interesting. So this was Act 64. In 2025, and you all appointed certain people to be part of this group. I'm going to tell you who was on it so you know. In addition to myself, we had Judge Zone, who was representing the court. We had a Defender General designee who was Marshall Paul from their office. We had a State's Attorney designee, Kim McManus. A member appointed by the Vermont Network, which is Sarah Robinson. The state police, which started out as Lieutenant Colonel Whitcomb, but he was kind of retiring. So Major Peterson stepped in and they worked on this together. A police chief, Sean Burke, who was fantastic. A federal firearms licensee, Henry Perro, who owns Perro's Gun Shop in Waterbury. The Center for Crime Victim Services, we had Megan Kinlock, who is the grants manager. And then from the Council on Domestic Violence, we had Heather, co-director. So we had a pretty good team of people who are stakeholders in this process and who understand the issues, the problems and the issues. We also had a whole list of consultants. And we reached out to those consultants to participate as much as they wished to do so. So you authorized us to meet 6 times, and we started meeting in July, right after the work group was formed, and we met through November. So basically a time to meet 5 times. We still could meet one more if we need to, and we might, hopefully, if this passes. And in the course of those meetings, we also had a special meeting that we invited all of the consultants to come and to say whatever they want to say. We also invited comments. And we did have, for instance, someone from the Fish and Wildlife who listened in, didn't really give comments. We had the Sportsman Club both give us written comments and also come and orally present ready and always were invited to listen in to all of these meetings. Yes. Chris Bradley came and he prepared some written comments, which were circulated to the whole group and discussed by us. Chris also participated by asking questions and introducing some ideas at the meeting that all the consultants were at. And of course, they were all invited to all of these meetings. So I tell you all that because I want you to know that we put a lot of work into this. And so I want you to know that like, this is not just sort of a proposal from my office. This is a vetted proposal with lots of different people's input. And the reason why we were working on this is because, and let me just flip to my thing, because we were really focused on the goal of prohibited people limiting their access to firearms they're not supposed to have. So one thing I want to be really clear about is, unlike all this other stuff that I saw in the firearms bill that the Senate's been working on, where there's new things going on about firearms, this is nothing new. There is no new firearm restrictions coming out of this group. Okay, so I think that's really important to be clear about it because it's quite different. It's really about the process, and the process, I'll tell you right now, it wasn't working. It wasn't working at all. We had FFLs who could be storage facilities, and we'd gotten to the point, and I'm happy to talk more about this with you all. And also I'd suggest you have Henry Perro in, who was our representative, if you're interested in hearing from him. But they got to the point where they didn't really want to participate because this wasn't working for them. And there are a couple of big issues for them. One is liability. So when this was first looked at, there was a provision that law enforcement would not have any liability as long as they're not like manhandling, not using the exact right words, but as long as they're being, careful and following their procedures, they couldn't be sued. There was no similar provision for an FFL. The other thing was the original statute required that if the person just never came back and left their firearms there, that wherever they left them, whatever storage facility, they were supposed to, if they sold the guns, then they were supposed to find this person they've had no contact with and didn't know who they were and return any extra proceeds to them. So it doesn't work. Who's going to take on a firearm on that basis? It just didn't work for anyone. So I'm telling you all that because it's really important that we move forward on this, because what we have right now, it's not working for anybody. And the program itself, this federal firearms licensee, the partnership there, I can't tell you how many more people are going to come back on board, but I can tell you that we tried to listen really carefully to what their concerns were and to make sure they were incorporated in the recommendations we are making to you, because they provide a safe storage option. So I want to start by explaining that when you look at this, there's kind of three things that can go on with a firearm. The biggest pot is law enforcement holding the firearms. That is generally the best option because law enforcement, they're serving the order. So when they go and they serve the order, if it contains a firearm surrender, some of the temporary orders, in fact, I don't know how many, don't require it. And unfortunately, we can't really find out those numbers because the judiciary doesn't track it. So I can't tell you. I wish I've asked for it. But it's not required at the temporary order stage. But in situations where the judge finds that it is necessary, the judge can order it then. And the law enforcement officer is going to that person to serve the order. That's kind of the best time and the safest time to secure the firearm. If it doesn't happen at the temporary order, it becomes part of the final order. And the firearm could be at an FFL after that. It could be with law enforcement. Right now, law enforcement doesn't charge. I don't know of any agencies that are actually charging to hold a gun. FFLs, they're business owners. They're going to charge something. And you all spent an awful lot of time looking at what you thought would be an appropriate charge. In fact, I was brand new to this job when you all first passed that law. And I remember sitting through, it was like a whole day of hearings, and it was all about like what they should be able to charge. So a lot of these other really important issues, like the liability, the other things, it kind of got swallowed by a lot of stuff that ultimately down the road, made no difference. Nobody's complaining about the fees. That's not the issue. But there's also the provision in our statute that a third party, if it doesn't place the victim at greater risk, can hold the firearm. And the problem with the statute is that it said that, but it never explained what the process was. Well, the judge can't figure out whether or not that is a risky thing to do unless they can hear from the third party. So there was no provision set up to explain how that should work. So that's what we're trying to clean up here, is to make it clear that the third party, if they're going to be holding the firearm, needs to understand and be before the court and understand their obligations. Because I'll be frank with you, it is a less safe option. It's a much less safe option. It's not like a firearm that's with an FFL or a firearm that's with the police. We have had many situations in Vermont where people gave the gun to their brother and then they asked for it back and told them the order was dropped, or told them, give me my gun back or I'm going to hit you over the head. I mean, who knows what they're going to say. And while there could be some liability on that person for giving it back, nobody was going through the process of making sure that that person actually understood what they were agreeing to. So some of what we've laid out here is making sure that that process is followed. And I'm not really following the order of my notes here, so I'm probably going to forget some stuff, but just stop me if you have a question. So I've heard some testimony from some of the other people about this third party, and they're saying, well, I don't think this work group looked enough at the third party because, third parties right now in Vermont, they can hold on to a firearm in some situations, like in an emergency or something like that. And that's true. That's has to do with a criminal statute, that has to do with background checks. But why it's important with a third party in this situation is it's an entirely different situation. It is a situation where the court is involved and is approving that third party. So we don't want to put our judges in a position where they are being asked to approve a third party. And some people seem to think that judges just can go on a computer and look and see everything about everybody. They can't see anything about anybody. They might know some things about the defendant if it's a criminal case and the defendant is in front of them. They're not going to know anything about this third party other than what the parties present to them. So it's important that the judge have the information they need to make a good decision. It's important that the judge have a background check. If the court is being asked to sign off on that and decide that that is a reasonable option, it's a less safe option. I'm not going to be I'm not going to mince words about that. It is a less safe option all around. But if the court is going to do that, they need some assurance that this person that they're giving the gun to is not a prohibited person. And they don't have any way of knowing that. They also need to know that that person understands their obligations, that person, if they have questions, like, is the order still in effect? Like, how they would go about finding that out. And that we already have liability in our law and under federal law. If you give a gun to someone who's prohibited, you can get in trouble yourself. And it's really important that people, before they take on something like this, they understand that. Go ahead.
There is no real provision, though, if it's from family member to family member, you don't need to have a background check or anything, even to the firearms. There's no transfer or anything like that.
Well, you would need to if you were coming in as a family member saying to the court that you wanted to hold the gun for a prohibited person.
Right, to hold it, but I mean, to give it to him. I mean, I could just give him everything I have to my son and say, here, these are yours, without any type of,
You're talking about transferring ownership.
Ownership, and I don't need to do an FFL Form 473 or anything to do that. And so I'm like, at some point, you're only going to make this so safe. I don't think there's a magic bullet because, first of all, how do you know you got all the guns? Part of the problem.
Yeah, well, you're right. There's nothing we are ever going to be able to do that can make people 100% safe that are in these very unsafe situations. But we can do a lot better than what we're doing right now. And when you transfer that gun to a family member, if you're transferring full ownership and you don't own it anymore, that already says in here, this doesn't impact selling a gun. This only impacts if you want your son to hold the gun and you are someone that the court has found has a relief from abuse or against you because they found that you abused someone and that,
I
that there's a
understand.
danger.
I'm very familiar with that part.
Okay.
But I'm like, I still own it, but I can't possess it. So can I give it to somebody? Can I have somebody hold on to it? It'd be the same thing as my car when I'm drunk on the street. I can't have my car or my keys. The cops are gonna take off with my keys, or I can give my car to someone else. It's the same liability there. But
Yeah.
me.
I think I understand what you're saying. And if you have somebody who is willing to come in and act as a third party for you and the court approves it, they could hold them. They could hold them, but the court would have to go through this process to make sure that they weren't inadvertently putting a blessing on somebody who's a prohibited person, for instance, holding the firearm. Does that make
That
sense?
makes sense.
Okay, and it's only applying again.
I didn't hear it that way, but originally, but that makes
Okay.
total sense. Third party, I think, is probably one of the best ways to get through this.
It's actually.
I know it's not, I know it's not, I know it's not tough, but
Yeah,
there's no place to hold them. There are places that are willing to take them, but I also think a big part of the problem is between the temporary order and the final order. If when they get the final order, that is when they determine that the firearms need to be surrendered. Going and getting them is going to be a potentially larger problem. More of a safety office for law enforcement than for if it was during the temporary order.
yeah,
Because
I mean, yeah,
they know it's coming.
yes, that's
And
true.
I'm coming to get your guns, and it's not going to be a good situation.
Well, they are in most instances not going to come there. It's on, because they don't have an order to serve at that point. The final order takes effect if the person is in court. The final order takes effect right then. There's no paperwork that they're then going out and
But
serving.
they still may be in possession of firearms.
Yes, they may be. And so it is on the defendant to figure out how to get that firearm either to the police
The
department,
defendant has to comply.
the defendant. The defendant either has to get it to a police department where they can store it, or the defendant has to get it to an FFL. And that could be having a friend take their firearms to them.
Is there any
Or,
follow-up to ensure that it's happened?
well, that's part of this too, is that they need to let the court and or law enforcement know, it creates an acknowledgement form that they are letting them know what they did with the
Well,
firearms.
we're actually asking the problem, to be honest.
We're doing what?
The person, the problem, to actually be honest with us, that they can be right.
Right.
I think that's dangerous.
Well, why do you think that's dangerous? What would be
Bring
the
your penny
option?
guns, keep 5 more.
Well, okay, you could do that. You would be,
Or let somebody else hold on to them for me without anybody else knowing.
yeah, but under current law, the only way somebody else can hold on to them is if they are an approved third
Right, but
party.
what I'm saying is, you're not gonna know about it.
That's possibly true. That's possibly true, but that's not a reason to not try to have some steps in place so that we know, for instance, let's say there's 5 court hearings that day. 4 of the people file the acknowledgement form and we know where those firearms are and the victim knows where those firearms are. It's a lot easier for police or investigators to deal with that one person where they didn't file the form and we don't have any idea what's going on. It's a lot easier to focus some resources around that than it is to have no obligation at all on the defendant to tell us what they did with their firearms.
Oh, no, I'm not,
Okay,
they are telling you, they're just not being honest.
okay. Yeah, no, I agree.
I
Lots of
think that's
people,
a terribly dangerous situation.
as opposed to what?
It's not a good situation either way. No matter how, there's no way to enforce this 100%. And feel comfortable about it, which gives us a false sense of security, I think, to victims and survivors.
Well, I can hear what you're saying, but I think sometimes perfect gets in the way of good, right?
No,
And so we could be doing a lot better than what we're doing right now. I mean, you could say that we are giving people a false sense of security if we order them not to
Well,
have
you did the
firearms
best
in the
you can.
federal government,
Yeah. Yeah.
and then we do nothing about it, right? I mean, that is a greater false sense of security than if we try to take some steps to ensure that it's actually done. You're right, we can't make
Right.
sure that it's actually done, but we can get closer than we are now. That's what we're trying to do. get
Have we
closer.
had any violation of restraining orders? For not having a firearm after the order?
Yes,
You know how many?
No.
No.
no. No,
I
but
just know because I've seen it from the work,
Yeah.
people do everything they can to, they'll comply as much as they have to, but not necessarily completely.
yeah, I
And
understand that,
that worries
absolutely.
me a lot.
I know, it worries me too. I completely agree with you. But, all we can do is try to inch forward and make things a little bit better than what they are. I mean, this is what, other states have decided that some steps towards compliance are
Yeah.
better than no steps. And right now, we're at a no step
I
situation.
agree.
You know what I'm saying?
We can pat that around a little later.
Yeah, I mean, the common goal here is to make sure that we are limiting access to firearms by prohibited people. We're not interested in impacting anybody else's gun rights. This doesn't have any impact on anybody else's gun rights. It's only prohibited people. And they're the people who have caused harm or have a danger of future harm to themselves or to others. So, okay, I got a little sidetracked there.
All right.
Not your fault, my fault. I want to just mention a few other of the recommendations that are in here. I mentioned that the third party, if there is a third party, again, less safe option, but we made a decision a long time ago that we were going to allow that if it was something that the court approved. And so that's the compromise Vermont settled on. But we're making sure that a hearing is held to ensure that that person understands what they're getting into, and that they're an appropriate person and that they have to have a background check. Another big change, one thing we heard from industry people was there's no reason to have ammunition as part of this because ammunition is hard to store. People may have a lot of it. It is hazardous waste, believe it or not, for the state police. So if they have to dispose of it, that's not good. And you can buy it. It's not regulated in the same way as firearms. So you can buy it at, a hardware store or something. So we've removed all of the references to having these storage facilities hold ammunition. We talked a little bit about the acknowledgement form, and if folks have questions about that, it's a really important piece, and it's designed to help people comply with the law, help people understand like where the firearms being kept, and for folks who don't comply with that, it gives law enforcement a better idea of who they need to perhaps go out and have a conversation with. And it will also allow, and this is a very important piece of this, victim notification. Right now, you go through this process, which can be a very difficult decision for someone to make, to go and ask for relief from abuse order. You've probably heard that before. And if they weigh that calculation and they decide that this is an important part for them feeling more safe, and then the court orders that the defendant not have any firearms, victims right now, they're not notified. They might be calling the court, they might be calling the police departments. They're just trying to find out where are the guns and what happened to the guns.
Yeah.
This takes a step towards requiring notification. If people are notified in court, then the law enforcement doesn't need to do it. But if they're not notified in court, both of the firearms being collected and also where they can't collect any. So like the situation you raised, where the victim knows they have them, the defendant says, I don't have any, and the police collect none. It's really important for the victim to know that, because then they factor that into their safety planning as well. FFLs right now, they can't, under this new setup we have here, FFLs can't be asked to store a firearm that is a temporary order. The reason for that is because we all decided that FFLs can't charge, no one can charge for holding firearm when it's only a temporary order. And so we wanted to make sure that FFLs weren't put in the position of holding a gun for somebody and then not getting paid. But that doesn't mean that the defendant's foreclosed from using them. The defendant can store their guns with an FFL right away, even in a temporary stage, as long as they understand and agree to pay the fees that are incurred during that time. We heard from industry that they wanted to change the 3 days that's currently in the statute to 72 hours after a background check is complete. And that's really because they felt that there was a conflict between federal and state law there, and that state law might be requiring them to give the gun back before federal law would allow them to. So we're just making it consistent and very clear that it's 72 hours after the person passes a background check. I already mentioned immunity, so now FFLs would have the same type of immunity that law enforcement has if they're participating in this program and they're following the rules. That's not to say they can willy-nilly do anything they want. They have to be following the rules. It also provides immunity if they end up selling the firearms because the defendant never comes. And that's another thing we heard about, because you probably know that one of the FFLs who participated in this program for a little while, they got sued. And a couple of things happened there. They didn't have any immunity for selling that firearm, which if they had been following all of the guidelines here, they would have immunity. And also there was poor communication because there was nothing set up designed to make sure defendant knows that their guns are now with an FFL. FFLs are going to charge. So we're making sure that defendants are given that information. We're also making sure that the FFL knows who they're holding the gun for, that they know how to contact that person so that in the event they don't come and claim it, they know who to reach out to. It also requires law enforcement to assist FFLs if they have a question, like, is this order still good? You know, this person came in and told me this order is no longer in effect. Law enforcement can verify that very easily for an FFL. So it creates more framework around this partnership. It's not all the work that needs to be done. That's another reason why this is so important, because until we get these pieces ironed out, we can't start to work on a law enforcement protocol. How the victim notification is going to work, we have a lot of pieces around that we need to work on. But what we need first is the approval from you all of this is the right path to be moving forward. We want victim notification of firearms, either being collected, not being collected, and also when the order expires, that the person knows that their firearms are going back to the person they had an order against, and they can make decisions based on that.
I'm tossing around the thing about they can't be forced to give up the firearm on the temporary order or store it if storage can't take it.
The FFL can't be required,
Right.
but the defendant can store it with the FFL.
Right. But what if they don't want to? That's, I think, can somebody push that issue, and where would it go? Like, I can't afford to give it to whatever right now, and I don't want to, or
Yeah, well,
they could be arrested for failure to comply with a restraining order, I'm assuming.
If they're not complying with the order, yes, that becomes a criminal offense. This does allow law enforcement who doesn't have storage capacity. That's another thing that needed to be changed, because law enforcement, small departments, some of them don't have the ability to store guns. So you're right. In some situations where a law enforcement agency collected a firearm and they didn't have the ability to store it, they would need to hold on to the final order, but then they could, with notice to the defendant about what their obligations would be, they could transfer it to the FFL that they had a relationship with. The defendant at that point is going to have all the information they need, either to know what those fees are, and the safest option would be for them, if they don't have any money, to borrow money from that trusted family member to pay the storage fee for 6 months. But if they don't go that route and the family member is willing to take this on and come into court and say to the judge, I understand what I am agreeing to do, they can be approved by the court and the guns can be transferred to that family member.
Was there any sort of provision in there for when the police did go to get the firearms, or search for firearms only, just to ensure
They
they
can't,
got them all? No, I mean,
legally.
is there any kind,
you know that.
yeah, well, I
Okay.
know, but I mean, is there any attempt even, or they just got to comply? You have to trust them to comply. I mean, we could also
Well,
ask for.
law enforcement have been trained to ask about firearms.
Yeah.
Believe it or not, that wasn't always part of their training. When they go and serve an order and the order says like, this person can't have firearms, some of the officers that they hadn't been trained that they should ask, that they should highlight that to the defendant. This says that you can't have firearms and it gives an officer an idea of maybe what firearms they have. Because, and again, I'm backing up a little bit. Some of
They're
the
looking
first.
for consent.
Hmm?
Consent. The
Yeah, they might get consent. They also might, by asking, they might, clue the defendant to this is something they need to do and they'd be in violation of the order if they kept it. And if you roll this all the way back to like when we started working on this, the forms themselves didn't even ask the victim if they had concerns about firearms. I mean, so lots of improvements have been made to both get victims who might be there just thinking like, I need a place to stay tonight. This just happened to me. They're not even thinking about the incident that happened the week before when they were threatened with a firearm at that point. This gets them to think about that so the judge can know about that and make a decision around that. And also make sure that police officers, when they go to the homes, they know, okay, the defendant is supposed to have these 3 firearms that the victim knows about. I'm going to ask about those. And you're right, they can't necessarily go in and search. But in the event that the defendant doesn't turn over the firearms and they have specific information that the firearms are still in the defendant's possession, they can go and apply for a search warrant and it becomes a criminal case. And there have been at least one instance that I know of a police department doing that and successfully recovering the firearms. But it's not a relief from use order is not an authorization to go into anyone's house.
Oh, Ian, you have a question?
I did. I don't want to interrupt.
No, please do. I'm talking too much.
No, it's really helpful. My question is going to take us a little bit on a tangent, but it kind of relates to on page 4 of this, the first bullet on suggestions for a model protocol, which is a legal removal of firearms that seem like a domestic violence, isn't it?
Let me just stop you for a minute because I don't know what we're looking at.
Oh, am I looking at?
Which one are we looking
Am I
at?
not supposed to be looking at
329?
the report?
Looking at the report.
Oh, the report.
Yeah.
Okay, sorry.
On page
Okay.
4 of the report was legal removal of firearms that seems of a domestic violence incident.
Okay, page 4.
The first bullet.
Yes, legal removal of firearms at scene of, yes.
So this kind of this brought to mind kind of something I'm curious if it came up in the working group, which is the I would imagine in many RFAs there is a sort of companion criminal case where there's a domestic violence incident. The individual is charged with a charge of domestic violence. The victim also applies for an RFA. In the criminal matter, they could have a condition of release for prohibition of owning a firearm. And I'm and I know for like from in my county, we have like a DV packet that is filled out by the victim, which assesses lethality risks. And one of the lethality risk check marks is does the offender, the person who did this to you, do they own any firearms? And that's a box that they check yes or no. And when I see that DV packet and I see that lethality risk checked, that's like the first thing I do is ask for condition 13 to keep the defendant from having firearms during the pending criminal matter of the domestic violence charge. And so there are many ways where maybe they get a temporary RFA, but then they don't proceed to the final. They never ask for an RFA. They just have this condition of release.
Mm-hmm.
Did it come up at all? Like, is there a way that we can sort of pull in individuals who are prohibited on the criminal charge from owning a firearm to access ways to kind of give up their firearms while they have that condition? I don't know if they're considered prohibited persons when they have that condition, but it's sort of I could just see it, I sort of see it as I don't know, like a gap where you could have somebody who is prohibited from having a firearm, but it's not actually because of the RFA, but it's arising from sort of the same moment. Does that, I don't know if that makes sense.
No, it does make sense. And we did not focus on that because there is a prosecutor involved in that
Yeah.
piece, and the prosecutor has the ability to reach out to police, and especially where they have a concern and they're hearing that the person has the firearm. The same types of storage places could be used.
Yeah.
And that order could qualify as a, order that allows an FFL to hold the firearm for them. So
Okay.
that, I mean, to the extent that that's helpful, I mean, a protection order can be defined pretty broadly under federal law. So like if they walked into an FFL and said, my sister's going to come in here and bring my firearms, I'm not allowed to have them anymore. And, that would be, they could participate in the program that way.
Okay.
And I'm glad you asked me that, because one thing I wanted to mention is something I haven't actually had a chance to mention in the Senate. And that's that this program, the storage program that's kind of on life support right now, it's being used in other ways besides just where there's a court order. It's being used by people who want to voluntarily store guns. And if you're interested in hearing more about that, one of the people we consulted with was Dr. Bell. And she can talk about harm reduction and how she's used this list. And I should back up and explain, in case you don't know this, that part of the work that we did with the state police was creating an interactive map. So any FFL who wants to participate in this, they're on a map that people can, they don't have to go into a police station and ask about this. If they want to go to an FFL, a really good reason for having a map like this is, let's say it's a concern and they don't really want everybody in their community to know their business, that their child is having issues and they just don't want the firearm in the house. They can see another county's FFL. They could go there and store the firearm there. And so Dr. Bell, if you have her in, she could tell you some great stories about the ways that she's used this map with training physicians to talk about how important it is to remove, they call it off-site removal of the firearm, and to use a place like an FFL, and how critical it is to figure out a way to partner with them so that people can use this. And they can use it like if they're going out of town for 6 months and they know that they have firearms that somebody might break in their house and steal. They're going off to college and they can't take their firearms, they can store it. But it's a really important program that we want to partner well with, and it's going to have far-reaching implications in harm reduction if we get it right. So I just wanted to mention that. I mean, Dr. Bell, she could tell you such great stories. She told me a story about an FFL in the southern part of the state where there was an elderly gentleman who was, the family was very concerned about him and he didn't want to give over his firearms. The FFL owner actually came to his house, talked to him, was able to convince him to let him take the guns. And so it is it is a good partnership. It can be better. And I think part of the ways it gets better is if we make this program work well for them. And I'm sorry, that got a little far beyond what you were talking about. But
That's really helpful.
well, I'm completely lost in my notes here. Is there anything you guys want to talk about? Any questions you have? Because I'm not sure I've covered it all, but.
Yeah, so when a firearm is relinquished, does it have to go to law enforcement or an FFL, or could somebody that's not an FFL store?
It needs to go to law enforcement or an FFL initially, because we have to have that step in there where if somebody who was not an actual storage facility, just like a trusted friend or a family member, that's permitted under our law. But we have to have a situation where that person is vetted, because we can't just have somebody saying, a defendant saying, which, as you point out, many people, not just defendants, lots of people. One of my favorite police chiefs says, people lie to us all the time. So they'll say, the firearms are at my brother's. We have to have a way that we can make sure that the brother has the guns, that the brother is eligible to have guns, and that the brother is willing to do this.
You want to start storing guns. as an income.
Well,
And what's going through my mind is, would they have to be approved for every case, or could they be approved once?
I don't know the answer to that, and I also don't know if legally I don't know what ATF would look at that as. I mean, if you are in the business of transferring firearms, there's rules that apply to you if you're running a business doing that. So
But there is the ability for somebody to be approved that's not an FFL.
yeah, oh yeah, absolutely. And generally that would be a trusted
that
friend
be
or a
me?
family member. Well, it could be
Yeah,
you
I'm
if
just
you
wondering
if
if
you
I-
wanted to do it. But the other thing, and this is something that has come up with people who are this is a question that has been asked is, well, what happens if the court appoints a third party and then the defendant never comes back to that third party? Don't we need some rules around when they can sell the gun? Well, you know what? That's on the defendant. If you pick somebody who is not very trustworthy, there is nothing really to stop that person from walking into an FFL and selling your guns the next day. Because if they have a driver's license and they are, anytime somebody's selling a gun to an FFL, they're not asking you to come in with a receipt of sale showing you're the legal owner of it. I mean, it's not as great of an option. It's not a great option safety wise, but it's also, there aren't a lot of things that we can do around that. If I give you my lawnmower and you have my lawnmower and then you decide to sell it on Front Porch Forum or something, I have a civil action that I could probably pursue against you if I can prove that I owned the lawnmower and you were just borrowing it or something. But the government doesn't get involved in saying well, once you've had a lawnmower for 30 days, then, you can sell it to other people. We don't create rules around that. That's sort of.
I know the FFLs aren't real crazy about doing this. I'm just going through my mind.
Yeah.
What if no FFLs in Southern Vermont want to do it? But there's a citizen that is willing to start a business and have a secure facility and start the story.
I'm not saying that they couldn't. I don't know. I think they would have to find out if they're going to be accepting payment for that and running a business that involves holding firearms. I think that's up to them to figure out if they can legally do that. If that puts them under ATF in some way.
Yeah, but shouldn't that be in the bill?
No, because we're not trying to create. It's really important to think about what we're trying to do with this. We're trying to limit prohibited people's access to firearms. Putting the firearm with a third party is a possibility if it's safe, but we're not trying to create some big broad category where we have people for hire that are coming out and being a third party. Like I said, it'd be much better if the defendant can't pay the storage fees if they borrowed the money from their trusted friend or family member to pay that, than if they're.
If there's no other.
Well, there's always police. Police are the biggest option. And then FFLs are another option. It doesn't have to be in your same county. And then if for whatever reason, the defendant doesn't want to go either of those routes, they can propose a third party to the court and ask the court to approve it. But if that's as far as we get involved in it, because the court's focus is whether or not that person, that third party, is going to limit the defendant's access to the firearm. Beyond that, who owns it, how long they hold it, that's a bunch of stuff that can be handled civilly and has nothing to do. The only time we're trying to create a system for that is when we're requiring the defendant to give their gun either to a police department or an FFL, somebody they don't have a relationship with. And as you said, maybe don't have a choice. We want to make sure that there is a process, a very clear process about when that party can sell the firearm if they don't get their payment of their storage fees or if the defendant just disappears. We have an interest in that because we're requiring that. We're never requiring some individual to come forward and say, oh, I'll act as, Joe Schmo's third party because I see it as a way of making income. Maybe they can do it. I don't know. But that's not really in the scope of this. Does that make sense to you?
Yes and no. What you said makes perfect sense to me, but it doesn't make sense to me I guess in a way not to have that option.
Well-
It might be to be determined if.
They have the option.
If police still, are at capacity, say, for what they can store and there's no FFLs, and maybe it's something that would have to be looked at.
I guess my question is, how hard is it to become an FFL? Because I know there are a lot of FFLs and in fact, folks that don't even have like some of the
Right.
gun
Yeah.
groups, they have people has applied to become an FFL.
I think there are people who can better answer that, like ATF, because they regulate those places. And I bet Henry Pero might be able to give you some insight on when the rules apply. Go ahead.
It's not regulated by the federal government for you holding on to somebody else's firearms.
Right.
It's Vermont law that keeps you from being able to transfer a firearm to another citizen. You don't have to do an FFL for a private sale in a state unless you have a state law that says you can't.
About that one.
We're not talking about sales though with
No, I
this.
know we're not. I'm talking
But-
about transfer.
Yeah.
So can we just walk through Tom's hypothetical? So
Yeah, sure.
you've got somebody in Southern Vermont, Brattleboro, and he's decided that he wants to kind of make a business out of taking guns for like holding guns for people who are prohibited for a period of time. They're not an FFL. So if I understand how this would work is they would go, the person who's got the RFA or potentially has a condition that they can't have a gun, they go to the judge and the judge is like, okay, so do you want your gun to go to the police? Do you want your gun to go to an FFL, or do you have some proposed third party? And they would say, I have this proposed third party. Here's a guy in Attleboro, he does this. And the judge would put him on the stand, the third party guy, put him on the stand, talk to him, put him under oath. Hey, are you going to keep this gun, not give it back to this person? What's your plan? How do you store it? All that stuff. Judge would weigh the testimony from the individual, like, is he credible, all those things, and then make a determination whether that person can take the gun. Is that kind of how that would work?
Yeah, but again, this third party thing, the way it was envisioned originally was really for people who had like a friend or a family member. And the idea was they didn't want to put it with an FFL because they didn't want to pay a storage fee. So if you start talking about somebody going into business, what I don't want to say to you all, because I don't know the answers to it, okay, is that if you started creating a business of being a holder of firearms, I don't know whether you would then become regulated by ATF. As far as if the person provides a reasonable alternative to these places and is going to keep the gun in a safe way, then I don't think the judge would have a reason to say no to it. But I can't tell you that this business itself is even. I mean, I don't know if it would be,
Right.
and I don't know what would be the purpose for it, because when you all first set this up, the whole reason you created a third party exception was just so that somebody could have, if they had someone, a trusted friend or family member to come and to hold the firearm instead of putting it in an FFL. I mean, FFLs already exist. Is what I've been told by FFLs is they have plenty of storage. That it's not a matter of they don't have any storage. It's participating in this program. They want to know that like certain things about it are going to work for them, but it's not that they run out of storage.
Necessarily have a special place for those firearms.
For what kind of firearms?
I mean, not even all FFLs have guns for sale. Some people just like to collect guns and it's easier for them to be an FFL, that type of thing, but not all stores have a place ready to store these guns. They're probably gonna have to build something.
Yeah, and they don't have to do that unless they want to do that. We have places who have storage already that's not being used, and the ones that are listed on the interactive map are ones that actually do have storage. So you're right, there are lots of like just kind of like mom and pop places that you can maybe buy a gun from, but they don't have an actual storefront. They don't have places that they could store your firearm, and we're in no way trying to make them store firearms or anything like that.
I bought a firearm from a friend that's an SFL and he doesn't have a store. I just went to his house and we did it in his kitchen.
Yeah.
And they got delivered to him and
Yeah.
transferred to
But he
me.
doesn't have to participate.
No,
You
he
have to have
doesn't.
participate.
Yeah, he doesn't have to. But like you said, if there's somebody out there that wants to create a business, maybe he decides this is a business. And I'm not saying that that wouldn't be allowed. It's
Right.
just that it
Right.
doesn't exist right now.
Yeah.
So all of it's very hypothetical.
Yeah, I mean, another thing that's going through my mind, that somebody who did that, it's gonna be safer with them than it is a family member.
Mhm. Yeah,
Possibly.
And I understand the third party thing and why we did it,
Yeah,
you know, and that type of thing, was we needed another option
yeah.
and, this would kind of be like that third option, kind of, maybe.
So Ken has a
3.1, but
I have a couple statements. First of all, anybody that tries to open up an FFL new business will be bankrupt because there won't be enough business, number one. Number two, trying to get a permit for it will be almost impossible. If you want to build a new building, good luck with trying to get an Act 250 permit for them. So so we're on that. The other thing is back in my days as a select board member, and you say, oh, we're just gonna take it to the police department, really? Okay, the police department goes and holds it. What happens if the gun gets damaged or they say it's damaged or stuff like that, who's responsible?
Well, as long as the police are exercising reasonable care, they're already, right now, under the law that we have, the one that's not working well, they're already exempt.
Right, so we all know they're gonna handle it with care, we all know accidents happen. So that's not gonna fly with me either, so I'm dead set against this. So, but trying to keep an open mind. I think we've heard testimony even from Henry that the FFLs do not have storage for this. I think anybody that's doing this on the side, like what Representative Burdick just said, as soon as people get wind that there's a lot of firearms in there, that's opening them up to the people that we're trying to keep firearms away from the most are going to have more crimes created there and more guns being stolen. And the other thing I just want to add, going on to this, is what I said about storage of FFLs. I believe it was Henry point blank said, and some others said, trying to get a serial number put on guns was going to be almost impossible because, first of all, there's nobody to do it, if I'm not mistaken, and second of all, the possibility of damage to the firearm to begin with. So it's I'm just going to lay it out there. It's just another way that a certain party in the nation wants to go and get more guns under their control and take away the rights of the Second Amendment. So that's my spiel.
John, did you have questions?
I thought it was very
Yeah.
diplomatic how
No.
I put that.
It was beautiful.
I'm curious, what's the return process like when if they're with an FFL and you get them back, or with a family member, there's some sort of
Yeah.
process?
Yeah, and it does talk about that, and it's also part of the recommendations is there's already a process right now where, you have to provide some paperwork that shows that you're able to have your gun back. And as long as you are no longer prohibited, which once the temporary order or the final order run, and there's no other order in place and you haven't been otherwise convicted, what happens is that whoever's holding it will do a background check on you to make sure that you can have your gun back. They'll make sure that, because they can't
So
give
they're
you a
gonna
gun.
run it next, basically.
Yeah.
again on your-
Yeah, like you were purchasing a gun, they have to make sure that because an FFL or a law enforcement agency can't give you a gun if you are a prohibited person. We don't want them to do that, right? So you could be prohibited for other reasons. You could have gone to another state and gotten in trouble. So they have to do that check. And then they have to make sure that whatever was the disability that was keeping you from having your firearm, like if it was a relief from abuse order or an ERPO, that had run, and they can check that. And if the FFL is not sure, law enforcement can check for them. And then they can get their, they have 72 hours.
A third party situation.
If it's a third party situation, that third party has signed a agreement with the court that they will not give you access to your firearm while you are prohibited. So it's on that person to figure out if their brother comes to them and says, oh, that order's not in effect anymore. If I were that person and I knew that I had that legal obligation, I wouldn't just rely on somebody's word. But that's really on them. They've signed a contract basically with the court saying that they are going to hold the firearm until that person is eligible to hold it again. So that's, then they can give it back and easily check in with the court, or they can check in with the police department, ask the police department to verify whether or not the order actually has expired. And if it has, they can get the guns.
Yeah, go ahead.
And just for the record, when I was going off on my thing, people that shouldn't have a gun, I just want to be very clear, should not have a gun. Those need to be dealt with, but the rest of this stuff is not near as easy as people think to go and do unless you want to confiscate guns from law-abiding citizens. Thank you.
Was there any conversation ever about, some firearms wouldn't be able to go to a third party? And some FFLs are not able to accept these types of firearms. Was that ever brought up?
You mean illegal guns that
No.
people aren't supposed to have at all?
No, highly permitted firearms,
Um,
Highly what?
permitted
Like a machine gun?
Yeah.
Something that's,
suppressors.
that would be a situation where the FFL or the police department that would know and check with ATF to find out how that needed to be held.
It could go actually undetected. But not itself, it could, but
I know ATF has rules around that and who
yeah, they
who can
do.
hold it and how, how you get permitted to hold a older machine gun and all those kinds of things. So we didn't have any special rules around that.
And
All right.
So I'd like to say, I know we're not looking at this law now, we're looking at how to improve implementation. And I'm very grateful for the comprehensive team that legislature passed, but the work that your office and you did to come up with this really detailed plan to improve the current situation. And I think we have to really keep that in mind, that we already passed the law and now we're looking at how to implement it better. And again, a lot of people, as you said, put a lot of thought and time into this, and it's important we honor that because we don't want to just kind of shoot from the hip in terms of changing some of the recommendations that, were not either were vetted already by your committee and, sort of undermine the purpose of setting up these committees.
Okay.
When was that law implemented?
Let me see. I can tell you, 2013. Are you talking about the first original firearm storage bill? Because that's what I thought you were asking.
No, I don't think that's what Representative Rachelson was referring to.
Act 64, I think, is put these.
Oh, what this group? Yes, that was, sorry. I thought you were talking about the original
It's fine.
20 VSA 2307. That started originally in 2013, but this study group was appointed by you all in 2025.
we did it last year, yeah.
Sorry?
Yeah, last year, right?
Last year, yes, last year.
So,
And so we were asked by you all to look at this issue and to provide you with these recommendations. And just as Representative Rachelson mentioned, that we operated in consensus. Everybody vetted this. We had 3-hour conversations about everything that's in front of you. Every one of those meetings, we met for 3 hours and we discussed all of these things and had some really knowledgeable people in the room thinking through what to recommend to you. So I did want you to know that they were consensus recommendations and that we did spend a lot of time trying to do what you asked us to do. And I appreciate the comments and I hope you find it, hope you find it helpful. If you have other questions, I'm happy to answer.
Anyone have other
I'm not
concerns?
done yet.
Oh, I didn't, sorry.
So I appreciate all that. And I believe when most of this started, because I've been here for 8 years, but I believe at one time when a lot of this gun legislation really has really been pushed was when the supermajority was in control. And since then, it's been back down quite a bit because of the threat of the veto. So I'm sure everybody is trying to make, including myself, trying to keep bad people that have guns, get them away from them. I think better enforcement of laws and holding people more accountable would do a lot of that. That's my opinion.
I agree with you. I think accountability is really important. And I'm happy to hear you say that you feel like we can all agree that what the purpose of this is to try to keep prohibited people from having access to firearms. So where you and I might part ways is that I don't think it's enough. Accountability isn't enough that we can punish somebody if they take a firearm and use it in a way we've never intended them to use it, to harm their children or their partner, and to kill someone. At that point, having accountability, being able to put them in jail, it doesn't bring that person back, right? So what this is trying to do is to take some steps so that we're not only holding people accountable, meaning when they break the law that we do something about that, but we're also trying to prevent them, save them from themselves, And you look at that case that just happened in Louisiana, you probably have read a little bit about that. It's a family violence case where there were numerous indicators that the defendant was suicidal. He said in front of his mother, if you leave me, I'm going to kill you. I'm going to kill all the kids. And Louisiana is, believe it or not, ahead of us in having a lot more steps around compliance. What didn't happen in that case was nobody had gotten an order. And so a lot of this is whether you then act on the information you get, whether the family could have thought about when the family knew that this individual was suicidal, whether to either voluntarily remove their firearms if they were willing to agree to that, or to pursue an ERPO, which we have in this state too. Or the wife could have gone and potentially gotten a relief from abuse order, because that's a really dangerous time, as I know you all already know. When somebody is leaving their partner, that person said she was going to divorce him. Very dangerous time, but she may not have been able to make the decision to get a protective order. But I mention that because those are the people you should have in mind when you're thinking about this.
Which clearly I do, not to interrupt you, but
Yeah, no.
that's pretty obvious. It's common sense.
Yeah.
And obviously, mental health didn't do their job, nor was there any accountability. The guy had the threats out there. He did all this stuff and nothing was done. So then it's blamed on the gun. It's not the gun that pulls the trigger.
Yeah.
It's the guy anybody that blows their family away, or anybody, quite frankly, that kills an innocent person, more than likely has something that has gone a little strange or something like that. In a lot of cases, there's warning signs and everything. The guy down there that you just referenced, plenty of warning signs, but nobody acted on it. We had a killing right close door of 2 parents that we knew, mental health. What did we do? Nothing until it's too late. But again, it's the gun.
Well, you and I agree on this. I don't think it's the gun, but I do think that a lot of times what happens in those situations is folks do reach out for mental health treatment, but the other step is removing access to lethal means. And that step needs to go hand in hand. So when you're getting the mental health counseling, it's not enough to have the person in counseling. I believe I read that the fellow in Louisiana had taken some steps, the family was trying to help get him into counseling. But the other thing we have to be thinking about is access to lethal means. And what can we do for folks in those situations that will help to reduce that risk. And you talked about it, lethality assessment. You know, when police ask about whether this person's ever threatened you with a firearm, we can look at accountability. We can look at, you know, is there a criminal charge? But we also have to be thinking about how do we limit that person from having access to a gun, especially in the situations I'm talking to you all about today. They're already prohibited. I'm not even talking about somebody who's just made a threat. I'm talking about people that the court has already gone through due process. The court has already held a hearing. The court has decided that this person is not legally able to possess a firearm. And that's the population we're focused on. We're not focused on everybody else that owns firearms out there or the guns. We're focused on the population of people who are already prohibited from having them.
Gotcha. And I don't want to disagree
Yeah.
with you all day because we could disagree all day.
I don't think we're disagreeing. I thought that we've agreed on all that.
But the thing is, you know, it's no different than those automobiles that I can see right there that can be used as a weapon, including the electric ones on the other side, right? That go the wrong way on highways and kill innocent people, that we have a mental health person that wasn't dealt with and killed some people that I happen to be in the memorial business for. So if somebody wants to do something, I think there's a set of scissors right behind me, and there's probably some things on this desk right here that people want to do something. I'm worried more about explosives. We never talk about explosives. My daughter was almost killed at the Boston Marathon there with the two brothers there with the pressure cookers. We should probably outlaw those too. So I got it, but.
No, I see what you're saying. Yeah.
All right, so.
I was just curious.
No, Tom was first.
Yeah,
Yeah, no,
Ron, and
just
then-
really quick, was anybody on the panel, did they leave like feeling everything was cared for? Did anybody have any open, grievance or?
No, everybody's got consensus. I mean, we would talk about a recommendation and then floor was open. Is everybody on board this? Any further discussion? Anything more that you want to say? There wasn't anybody saying, I don't agree, I don't want that. And then us just saying, well, we're doing it anyway. So, you know, we thought it through. There are compromises built in here. And it, like I said, this is just a first step.
Yeah.
I mean, there's a lot more work to be done. That model law enforcement protocol is going to be really important. And there's some issues that need to be resolved, but we're trying to just bring you the things that we know that you can fix. We know you can't do it all. There's still a lot of work to be done. Go ahead.
Thank you. We worked on red flag laws a few years ago.
Yeah.
And I think we've worked on a couple of them. And I know I'm pretty sure I supported some and didn't support some. But one thing that we did do, no matter if I supported, you know, whatever we did back then or not, is we said we have to take firearms away from people who shouldn't have them. I don't think anybody has a problem with that. What we didn't do, we didn't set up a system for storage. And that's the way I look at this. This is simply storage. Is it perfect? No. You know, Tom brought up some issues, you know, where somebody might not give up all their firearms. I brought up issues. Maybe we're not going to have, you know, enough people doing it. But we just need to say storage. And a lot of times I try to keep things simple, and that's the way I look at it. This is for safe storage of firearms, plain and simple. It's a system that people in the industry, people in law enforcement, people in law came to a consensus to do. And overall, I don't have a problem with it. It's not restricting any Second Amendment rights. You know, if Second Amendment rights were restricted or gone against, we did that a few years ago, potentially. And we obviously didn't, because they haven't been challenged, and red flag laws are everywhere. So overall, I don't have a problem. And you know, and maybe in the future, if you know, that there is an issue where people aren't giving up you know, the firearms the way they should. You know, the way they're ordered by the court because there's an issue with them. You know, maybe we have to come back in here and do something else, to tweak the law. In some way, get them to give up, you know, the rest of the firearms, or maybe we have to come back and give a fourth party an opportunity maybe to store firearms, but, yeah, I don't even look at this as a law. I look at it as, our failure to do our job a few years ago, as far as expanding on the law, I guess you could say, because like I said, we said you have to relinquish them, but we don't know what the heck you're gonna do with them or where they're gonna go. And this stuff, yeah.
Well, thank you for saying that. And I hope you don't feel like I neglected on the ERPOs, but
No,
I think it's just important for people to know that like to date, the court's only getting 30 to 40 of those a year. They're getting a lot more relief from abuse orders. That may very well change because some of it is, you know, like you said, the laws are pretty new.
Yep.
But this procedure, to make it simple, covers the same thing. So the ERPO law, this also suggests that you amend the ERPO law to simply say, refer to this firearm storage statute for the process. So we don't have different processes going on. We have one process that can be used to secure firearms for both types of protection orders.
And this tweaks the law from what we did a few years ago, and like I said, maybe we gotta come back next year, or 5 years down the road, tweak it again.
Well, thank you.
That's at least that for our.
Depending on what happens.
So I'm sorry, I know we will want to end, but I just again can want to point out and remind us all that when we talk about mental health people, I think I know what you were trying to say were people that were struggling with mental illness, and that frankly, most like the data shows that people who struggle with mental illness are most likely to be the victims and not the perpetrators. And I know we have gotten feedback from a lot of our advocates when we say these things and nobody reminds us about that. So I wanted to remind.
I appreciate that. Can I respond?
Yeah. Go ahead.
So her feedback people and my feedback people are two different things. You just had another shooting in South Burlington. I wondered what that's about. You know, we talk about all this unfairness stuff and all this stuff. You look who's doing it. It's the drugs, it's this, it's that, it's all that stuff. And again, we are not going and holding people accountable and keep getting the people off the streets that need to be. And then I listened to overcrowding of prisons, which maybe we need to build bigger prisons because maybe the state will be safer. And maybe if we stop the people that are coming in the state that are bad, that are running the drugs and the sex and all this stuff, I see a head being shaken, but that's fine. But it's the way it is. So I said I was done talking. I'm done talking because all I'm going to do is get more frustrated. So that accomplishes nothing.
So we don't have Ken any more frustrated. We're going to adjourn until Tuesday. I don't think we have anything else on the calendar that's coming over.
Cool.
I think so.
Hang on,
What day is it today?
Friday.
Today's Thursday, so we don't have anything on our agenda for tomorrow.
Oh, we don't, okay.
Okay.
You know, I'm gonna start recommitting stuff to you. I'm sorry.
I can look for something if we, I mean, you know, we can be after the, what is it?